So I was a lot younger looking then, so I was the young person mediator, and I realised that there's a lot of applications for this, what we call, it says alternative dispute resolution here, but now people call it appropriate dispute resolution or primary dispute resolution. So when I started working for Dispute Settlement Centre many, many years ago, talking to the legal profession about what mediation was a difficult task. People didn't study it in high school. We didn't study it at Monash. So people kind of saw it as the heavier than air flying machine. You know, it sounded good in theory, but it doesn't fit with our experience of how people resolve disputes. People need to be in a room, they need to be kept in control, they need to be asked the right questions, and a wise person will make a decision for them. And that still works in a lot of contexts. But there are a lot of situations, and the Dispute Settlement Centre where I work for was one of these places that sprung up in the 1980s, because that doesn't work for a lot of situations. It doesn't work when you have people who live next door to each other and they're in a dispute, because they can go to court, the court will say one person's right, one person's wrong. That's not going to change their attitudes or their feeling to each other, and they've still got to live next door to each other. Same if people were in a workplace or they work they're part of the same school community. But what we were telling people is a bit like the mystery box. We're saying people come into mediation and they're unhappy and they're stubborn, they don't want to resolve, then somehow they go through this mysterious transformating process and they come out with an agreement. And part of the problem is that mediation is completely confidential, so it's hard for people to come in and see what happens. It's not like a court where you can go into an open court and observe a trial process. But it's not just a free-for-all mediation, it's actually quite a structured process. The important thing is we have to make sure that people, first of all, trust us, that they trust us to help them solve the dispute. And then we slowly teach them to trust each other. So it's important that, like a judge, we remain neutral, we remain confidential. But also we have to make sure that people are willing to give this a go. When we say voluntary, and I'll talk a bit more about the different programs we have, not everybody comes to mediation because they're voluntary. The first thing that I was told when I was doing my mediation training is don't ask people if they're happy to be here, because they're not. They're here because they're in conflict. What you want to do is ask them, are they prepared to talk to each other and listen to each other? The other important part about mediation is that there is some structure, there is some steps. We're taking people on a journey from disagreement to agreement. So it relies on them being able to talk to each other and negotiate. And the problem is that a lot of that communication is broken, so that's our role as a mediator, is to build that up. So it's a very different dynamic from what you're achieving in a courtroom. I sometimes use the analogy of a car. For those of you who are learning to drive, or if you've got your licence, you know that the first thing you're meant to do when you sit in the car is have a look in the mirrors, see what's behind you, check the instruments to see everything's running okay, and then you move off. Well, in a mediation process, it's a similar idea. When we get into the room, people are going to talk about the past, they're going to talk about everything that's gone wrong. And in many cases, there are going to be things that people are going to agree to disagree, but they need to get that off their chest. So that's important, that we give them, usually we start off, each person has separate time in front of the other person to describe what's been going on, their view, their perspective of the matter. Then we start a dialogue around the key points, and we start moving things to the present. We start getting them to talk about how this conflict has affected them, like where are they at? Because they haven't come to mediation because good things have happened. They've come there because bad things have happened, and they're going to be facing some unpleasant consequences if they can't resolve it. It could simply be that they'll be living next door to each other for a long time and they'll hate each other, or one person will have to sell their house. Or they'll be going to court, and both of them will be up with some significant costs. So we get them to reflect on where the conflict's got them. Then we start talking about the future. Then we start generating options. Now, the really important thing, and this is the thing that is very different from the court dynamic, is that we're putting the power of the people who are in the dispute to make the final decision about how this gets resolved. Okay? They've got to decide this is what's going to work. For one clear reason, well, we the mediators aren't going to be there afterwards. So it has to be something that they think is going to work for them. And the other thing, and I call this stickability, is that if you've actually had a part in crafting the solution, if it's your bright idea, then you're not going to go back on your word. You can't blame somebody else. You can't say, well, that mediator told me to do this, and what the hell does he know? It's your idea. Before I go to that slide, I might just give you an example to put it in context. A while ago, I had two families that were in dispute over a fence. Yeah, as you know, if you have a dividing fence, if it needs replacing, then neighbours are meant to share the costs. Usually they share it 50-50. But in this case, one neighbour decided that the wooden fence that was there had had its day and he replaced it with a colorbond fence. He didn't notify his neighbour, didn't ask them to contribute, just pulled the old fence down, put it up and sent the bill. The other neighbour said, well, I know the rules around fencing, I know the Fences Act. You've got to give me notice, we've got to sign an agreement, you didn't do that, so I'm not going to pay. Okay. That was 7 years before the mediation occurred. The person who had the colorbond fence had moved out. That's not why they were at mediation. They were there because they were living in the same neighbourhood. They met up in a shopping centre and they had a punch on. Okay? So it was the two adult sons who are now facing charges of assault, and it was the two parents, the two fathers, who were applying for personal safety intervention orders against each other. Now, the court had decided not to grant the orders. The court had decided to give them an opportunity to sit down and talk about this, because clearly this was going to become a bigger vendetta. So I get them, we go through the process, they each tell us the history of the matter. We get to that discussion where we talk about, well, why has this conflict gone on? And the guy who pulled down the wooden fence, he said, you know, what really gets to me, he said to the other bloke, you got to pay, right? You got something for nothing. You saw me build that fence, you didn't contribute a cent, and that's what really incenses me. The other guy said, it's not about money, mate. This is like it's $1,000. I could pay that tomorrow if I wanted to. My business is good. I don't need that. But what gets me is that you didn't follow the rules, right? You are not going to see a cent of that money because I just don't think it's right or fair that you should benefit from this. Now you think, well, that's pretty intractable. But when we broke and had a private chat to them, they both kind of understood, you know, I understand where that guy's coming from. I don't agree with it. So, well, what is your concern? He said, well, I don't want this dispute to continue. I don't want to have an order against me. I want to be able to go down to my shopping centre and not look over my shoulder to see if I'm breaching. I don't want my son to be facing, you know, more charges. I don't want to have this escalate and somebody gets a knife in the guts. The other guy said pretty much the same thing. So when we got back into talking about what are options, one of the things we asked them, when we asked Mr. You got to pay, I said, does it matter where the money goes? Thinking, well, you know, the money actually goes to a fencing contractor and they've got bills and kids to feed. He said, yeah, look, if he paid money to a charity, I'd be quite happy with that. The other fella said, hey, I'm a generous guy. I'm quite happy to pay money to charity. You tell me what charity, I'll pay $1,000 to that charity as long as you don't see a cent of it. And so that we achieved agreement on the spot. A cheque was written, we posted it off, and they both walked away. Because what they had achieved is they'd achieved closure. That's what they really wanted. It was no longer about what was right and what was wrong. It was about how can I get an exit point from this escalating conflict? But also, how can I do that and save face? And the other thing, and this is why this one sticks in my mind all along, is that there's no way I would have come up with that idea myself. They came up with that idea, so it gave them satisfaction, so they were happy to carry out that agreement. Now, I should say that mediation fits in a broad spectrum of these things called ADR. You might have heard of some of these things like conciliation, arbitration, early neutral evaluation. All of these things are essentially intervention by somebody else, but trying to help the people involved in the dispute sort it out themselves. And I guess what differs is the degree of control that the people in the dispute give to the third party who's helping them to resolve. So in mediation, we say what we're really doing is controlling the process. We're controlling the discussion, but the people involved are just controlling the content. With conciliation, there's often a bit more advice and process information given to the people to help them resolve. When you get to arbitration, it's still the parties who nominate who resolves the dispute, but it's the arbitrator who's the one who might make a decision. So, just to let you know that there are a lot of different organisations that now practice some form of appropriate, and this is not the whole lot, this is just what I could fit on a slide this morning with a few pictures. So in family mediation, we have the Family Mediation Centre, Relationships Australia, LifeWorks, and even Legal Aid have a roundtable dispute resolution process. So where both parents are recipients of legal aid, they may have to go through a conferencing process if there's a dispute about children. You've got professional bodies like the Resolution Institute, Vic Bar, the Law Institute, all have lists of mediators. So they're people who practice as lawyers, but they also have a mediation practice. Then you have government schemes like the Work Cover Authority that do conciliation to resolve work cover claims, the Victorian Small Business Commissioner, Fair Work Ombudsman, even the Equal Opportunity and Human Rights Commission of Victoria have conciliation. So what's happened is over the 20 years that I've been involved in the legal profession or the legal side of things is that there's been a real shift in the emphasis of government and in the courts to try and do as much early dispute resolution, conferencing, call it what you will, mediation, to try and get disputes resolved. Our service, Dispute Settlement Centre, we're actually part of the Department of Justice. We used to be called the Neighbourhood Mediation Centres. There were sort of a small number of them in each suburb, so it got centralised and became a statewide service. And the beauty about our service is that there's no enabling legislation. So there's no restriction that says you can do this dispute or you can do that dispute. So we have a number of streams. One of the biggest we call a community. That's where people self-refer. And it's usually people who are in some kind of relationship. They know each other, they keep on coming into contact with each other. So if you've got a complaint about a toaster, that's usually not something that would be suitable for mediation because there's usually a contract, there's a way you can resolve it and negotiate that, there's a complaint management service. When you've got neighbours and it's more about how you interact, that's more suitable for mediation. So the second chunk, that little blue one there, is their police referrals. So once again, it's often neighbours and family kind of matters where police have attended because somebody's called up, there's been a problem. They then have a portal where they can refer cases to us. We also do matters under 40,000 in all the suburban courts in Victoria. So that pre-hearing conference that I went to 20 years ago, that's now a mediation run by the Dispute Settlement Centre. And finally, personal safety intervention orders. Now, does anyone know what they are? Yeah. They're a strange legal beast. They're somewhere between civil and criminal. So if you've got somebody and you are afraid of their behaviour, they're scaring you, it's a constant pattern of behaviour like stalking, you can apply for an intervention order. If they're a family member, it's a family violence intervention order. If they're not a family member, it's just a personal safety intervention order. So what the Magistrates Court found out was that the people applying for these kind of orders, up to 50% weren't being stalked by their neighbours. What had happened was they'd had a conflict or a dispute where the behaviour had escalated, you know, shouting, swearing, threats made. But they weren't actually being stalked, so they didn't actually meet the criteria of the legislation. Now, if you do get a personal safety intervention order, the magistrate can make a whole list of restrictions about who you can communicate with and who you can talk to. So if you actually have a dispute with your neighbour over the noise that they're making, or their kids climbing over and picking up footballs, which happens, you can't actually talk about it or solve it once you have a personal safety intervention order in place. So we work with the courts. We go there on the days that these matters are heard to see either people will put an exception in the orders that they seek, or they might stand down their application for about a month so that they can have a mediation first and see if they can come to come to an agreement to the underlying issues. So these are the kind of matters that best suit our service. Now, as you saw, there was a lot of family mediation services out there, so if it's a separating couple, we would generally refer on to other services. There are a lot of different government schemes around the Fair Work Ombudsman and other organisations that resolve issues around wages and that kind of thing. But we get a lot of workplaces where there's not necessarily bullying, but there's problems of communication happening in the workplace. So we're often asked to help out with those kind of matters. But a good 75% of first call-outs are neighbours, probably because that's what we're best known for. We have offices around the state. The biggest one is in Melbourne. Most people who contact us will call on a 1300 number, so their initial contact is usually with our office in Melbourne, and then we refer people out to our rural offices. And the other thing is that a lot of what we do with these initial calls is we don't actually mediate them. Because if I say to you, I think the best way to solve your problem is to put you in a room for 3 hours with someone you don't like and talk to them about the reason why you don't like them, you're probably going to be reluctant to do that. And what we really are aiming to do is primary dispute resolution. So we're trying to skill people up to have their own conversations with their neighbours. So we'll do a lot of coaching over the phone. We'll say, well, when you last spoke to your neighbour, what did you do? What worked? What didn't work? Had you got a clear idea of what you wanted? Because a lot of times people say, yes, I've had a discussion with my neighbour about the noise issue, but you find out that discussion happened at 1 o'clock in the morning when they were sleep deprived and they were angry because the noise had woken them up. So they haven't had a proper sensible conversation with their neighbour. So sometimes we just act as a circuit breaker. We'll send a letter to the neighbour will call us back and say, look, sorry about the problem with the noise, it's not going to happen again. Can you let the neighbour know that we won't need to come to mediation, we'll keep the noise down? So of every 10 calls that we get through, only 3 or 4 turn into an invitation for mediation. And then one of those usually resolves without having to come into a meeting room. One of those people will decline, will not be interested, and one of those will go to mediation, and 90% of those resolve. The other thing we do is training and workshops. So, a lot of what we have to do when a person contacts us is see where in the spectrum of conflict their dispute lies, because that will determine whether they even need to come to mediation. So often, a lot of times, people are calling us up because there is a simmering issue. There's a fence that's about to fall down. So all they need is information on what their rights are, so they can then talk effectively to their neighbour. Other times, we've got to the point where there's been a crisis. And if that's a point where there's been violence, or there's been somebody's thrown a hissy fit, for want of a better word, they've lost their temper and screamed, then sometimes that's not the best time to send a letter, say, let's get together for mediation. We need to let things simmer down. So it's that kind of midpoint. The timing is very important, because what we're effectively doing is like an act of diplomacy between neighbours. The other thing we have to make sure is that it is actually safe to get people to meet together in a room. So we always do an extensive interviewing process. A lot of that's over the phone, where we make sure that there is no risk of violence, that people are going to come into the mediation in an attempt to resolve things and not simply to harangue the other person because they're angry at them. So, and the other thing is to make sure that they've done their homework and that they, if it's a dispute about a building works, for example, they've got quotes, they understand what the cost of works are, they've got a clear idea of what their claim is. So the key selling points for mediation, and this is why it's become far more popular in our legal system now, is that it is cheaper, simpler and an alternative to taking disputes through courts. Now, mediation still takes some time to plan because people have to give up time from work, childcare, we need to book mediators. But you know, in the legal system, a full trial could take months to organise in the magistrate's court, and they're the quick ones. We also say that it can produce better outcomes. So again, that depends on what the people want out of the process, but you can often actually get neighbours who end up coming to agreements to do things to help each other rather than simply arguing about the things that irritate each other. I said 9 out of 10 was 85% of mediations that come to us do end up in agreement, and also we always survey people after the mediation. So we send out the Survey Monkey and we're getting back an 85% general satisfaction with our service, which has been a constant for at least 15 years. The other thing that we do, and I won't dwell on this, but just simply because this is my job now, is there are many communities out there that might not actually trust Big Blue with their disputes. They don't want to come to the Department of Justice, even though we say it's completely confidential, you can trust us, we're not part of the court system, we're a separate service. Historically, a lot of people don't trust the Department of Justice, but they do have their own processes in their own communities. So what we also try to do is build up the capacity of community leaders out there to resolve disputes in their clubs, in their organisations, in their church groups. And there's a number of reasons why we do this. One is it is a KPI for us. It's, we report back to the state government and say, this is how we've spent your money well. It's a driver of business for us. People don't necessarily know about the dispute settlement centre, so we need to increase awareness. It's a good process for us because we learn more about the community and we can change our service and make it more effective to help people. And sometimes, it's about just setting a good outcome with the community. So, here are the key, my key selling points. Whenever I talk to a group of people, I say, why would you use a dispute settlement centre? Well, there's the 3 Fs. There's no fees, there are no forms, because we're aiming to get people to talk to each other. That's the primary way of disputing. We don't want people to be writing long complaints about each other. No fuss. We will be the ones who contact the other person, sort out the time and the date, make sure that everybody's prepared. There's also no guarantees, but that starts with G, so I don't put that on the list. But remember that the mediation service is part of a broader scheme of dispute resolution. So if matters don't resolve at mediation, you still have the court system, you still have your other options. What we're giving people is a tool for earlier intervention. And of course, it's completely confidential and empowering. So I'm going to finish off with our contact details, but you have our brochure there if you're interested in finding out more about our service. In terms of timing, how much time do we have for questions? Because I know we started late. Okay. No. Yeah. I think people at the back, we ran out. We did all the front rows and ran out at the back. You have a question at the back.